Good evening. So very interestingly, the last session is the law session. So hopefully everybody stays awake in this. Now, a bit about me. My area of practice primarily has been cybercrime litigation, data protection compliance, corporate data espionages that have been very common. And now, obviously, some kind of legislations that are coming into place, which we'll discuss further as to how a lot of things which were unregulated are getting regulated right now and how that's going to impact your organizations. So I have been practicing in this space since the Information Technology Act came into force. And that's been a large span of time. And over these years, there's a lot of development that has happened in the space of technology laws, primarily with the fact that if you see the way technology itself has developed. Just to give you an example, when I started practice, Blackberries were just entering India. There was no concept of smartphones. I myself never had one at that time. And the whole objective or thought process that whether or not there will be crime. So when I took up this field, a lot of people said, there is nothing happening right now except for financial fraud. So where banks were targeted. Within a year of me starting practice, banks were the major targets for financial data. Banks were targets wherein the net banking process had just started. That too, using websites is what people were doing. And, there were compromises at that level that were happening because the rest of the world was more advanced. So India was even then being targeted. It was not being advertised. It wasn't in the news as much. But yes, banks were the ones which were first targeted. And then in today's times, where you see almost every crime today has a digital angle to it. Now, I'll give you one simple example. There was a point of time, I will say that in Hindi, because the word itself is like that. आप ट्रेन में जाते थे या बस में जाते थे, आपकी पॉकेट कोई मार लेता था. Correct? Today, the same thing happens with your digital wallets. It's just that somebody doesn't need to come and slit your pant in order to obtain that or slit your shirt to get your pocket. So the whole concept has changed. There was a point of time there were Romeos stalking women outside schools, colleges. Do you see that happening as much right now? Not really. So it's not that the crime rate has reduced in India. It's not that the outraging of modesty of women has reduced. It's not that, you could say there were a large number of cases of defamation where people would make wrongful statements against each other. There were cases where what we call battery, assault. Now, does that happen in the physical world? Do you see that happening very often? But it's happening in the digital world. There's online defamation, there's online stalking. Battery and assault has gotten converted into a very different angle altogether, where people on social media are bantering and trying to pull down their employers in some or the other way if things have not gone on right. Husband and wife trying to pull down each other over the internet. So there is assault happening, but on a different medium. So that's exactly where we come to the point as to why regulation of the digital space and data has become so important. Giving you a simple example, data between husband and wife is also very important to regulate. This I can tell you from personal experience wherein on a day-to-day basis, there are so many cases where husband and wife, either of them, whoever is undergoing a divorce or a separation, will end up approaching that, I have obtained so-and-so data about my wife from her cell phone, from the laptop, from the bank statements, and can we present this in a court of law? Or they go and present it in a divorce proceeding and the judge says, okay, that means you've committed an offense. How can you gain access to such data? So you need to understand data is not just corporate data, that's one thing that we're going to talk about, but also your data amongst yourselves. So the concept of sanctity of data, whether it is with a spouse, whether it is with your children, whether it is like children above 18, below 18, you are the guardian. So yes, you decide everything. Above 18, that line of, how you're using the data, what you're accessing, all of that is applicable. So just to give a fair idea to you, there was a landmark case which was there where, the wife had obtained access to the husband's WhatsApp records in order to, show that there was some form of adultery going on in a divorce proceeding. Interestingly, after that, the husband had filed a criminal case with respect to unauthorized access. It is unauthorized access. The matter went up to the High Court. And thereafter the Supreme Court, and it was held that the wife, despite she may be separated, she was the wife, still divorce may not have happened. But even in that relation, data protection is something which is very important. So you cannot unauthorizedly access your spouse's data and make any kind of misuse to it. As a matter of fact, that would involve you committing an offense. So that is the backdrop in which I'm bringing you around to, wherein in India we don't, I think this is, So in India, we don't really have the privacy mindset. That is where I was coming to. So we suddenly have an act that has come into place, the Digital India Data Protection Act. I'm quite certain all of you are aware about this act. Now, the act has come. Are we as individuals and organizations ready? That's the most important question. We don't have a privacy mindset. How many times would you have sat down and, if your friend is typing something on the computer or the mobile phone and you've peeked in? How many of you would have done that? Your husband or your wife, here I think there are more men. So your wife is typing something and you've simply looked in to see what is she doing. Nobody's raising hands, but I'm 1000% sure you've all done that. So in India, unfortunately, we don't have privacy as a concept. The single example which I always give is that, if you go to countries like Finland, privacy is ingrained into individuals. So if you are, let's say, talking to somebody or you visit their house and you ask, okay, how is your wife doing? That's taken very offensively. You may be a friend, but you have got nothing to do or know what is going on in my family. The same thing here in India, even if you don't know somebody, you're walking on the road, or you're sitting in the train next to them, you're going to discuss your entire life with them. We are open to sharing. That's one of the key reasons why India is one of the biggest markets for data analytics. So you see on Facebook, we are oversharing. Instagram, we are oversharing. We love to share so much about ourselves. And that's what makes us the most lucrative market for almost every other social media organization which wants to profile you. So with the act, if you know, before this act was enacted, there was a concept of data sovereignty, wherein organizations had to process Indian data within Indian boundaries. That was one of the key reasons why this act was not passed for a long time, because a lot of big giants had major issues with this. So a lot of people believe that the act has been passed without data sovereignty. That's not true. So there is a particular section on cross-border data transfer. We're going to come to that later. But just to give you an insight into that, that clearly highlights that certain categories of data, the government is going to determine and give a notification list that certain categories of data and certain organizations, they will have to process Indian data in India. So everybody it may not apply to, but the government is going to take out a circular list of what kind of data. So obviously your sensitive personal data is going to come into that ambit. And a lot of organizations which are into large-scale data processing, tracking, profiling, all of those are going to come within the ambit where they will have to process Indian data in India. Why is this so important? Today, when any crime is committed against any individual and you go to the police station, you file a FIR. This is what I'm telling you from the practical perspective, what happens. The police writes an email or a notice to, let's say, the internet service provider or the social media platform or any other organization which is having that particular data pertaining to the crime. Now, major social media giants, major ISPs are not located in India, or even if they have presence in India, like they're offering services in India, but their head offices are located, let's say, in the United States of America or any other country of Europe. So what's the standard revert that comes back? We are governed by the law of so-and-so country, and only via court order will we comply. Now, how many of you will actually go to the United States or Europe and get a court order in order to obtain a piece of information? And do you think the Indian police can really do that? So the entire judicial system or the system fighting crime gets entirely defeated. So having Indian data within Indian boundaries becomes of key importance, especially sensitive data, in being able to enforce law in the first place. So let's come to the next point, applicability of this particular act. Now, what is the applicability of the act? It applies to all forms of digital personal data. Personal data, simply any data that identifies you as you. It may be your name, your email ID, your banking information, your sexual orientation, anything and everything about you that can identify you as you, or is a cluster of information about you. All of this comes within this definition. So your health conditions, everything. Now, when is it applicable? When there is digitization of this data, so in a digital form, if this data is collected by somebody called a data fiduciary. So who is a data fiduciary? The organization or individual who decides what data should be collected, how it should be collected, and what is done with it. Who's a data processor then? A data processor is one where the instructions of a data fiduciary is going to go about processing your data. And who are you? The data principal. It's your data, you're the data subject whose data is being processed everywhere. So in the event any digital data is collected about you, then in that situation, this act is applicable to you. Now you need to understand one thing, there's a second angle to the act. So if there is a digitization of physical data, so in the event any physical data is collected about you, let's say you've given any physical information, your PAN, your Aadhaar, you have given any physical form in which you have filled up data about yourself, and there is a picture of that taken, or a scan of it maintained, or the data is what we call data entry into any other software or platform. In that situation also, this entire act is going to apply. Now, when you see physical data and digital data, the boundary is very, very difficult to bifurcate. Today, any organization may say, I will only collect physical data. When a data breach happens and the data is available, let's say on the dark web or any other place, and there is a data breach, you will end up having to prove how did this data get digitized in the first place. See, any person, whether it may be a miscreant employee, whether it may be some person who has leaked the data, will very rarely in physical forms take the data in a suitcase and take it out of your organization. Normally, when corporate espionage with respect to data happens, it's very, very simple. Like, people simply take images or in some or the other form digitize the data. And the burden of proof to prove that the data was physical is going to lie on the organization. Something that you can definitely not prove, that you would not come within the applicability of the act. So you need to be rest assured that today, almost any and every organization, small, medium, large, is going to come within the ambit of this act. Now, some people, how many of you here feel that your organization may not come within the ambit of the act? How many of you feel that? By a show of hands. Everybody feels your organization will come in the ambit? Any particular reason why you feel that? Anybody can answer, please? Anybody? You feel your organization is going to come in the ambit. So why do you feel that? Yes, that is one point. Another point, any other point that comes to your mind? Yes. So even if you're processing one individual's data, personal data, you're going to come under the ambit of this act. So let's say an organization says, I'm not processing client data, I'm not profiling any third party, I'm not doing anything. You have that one employee whose Aadhaar information you have collected or whose bank details for salary you definitely have. You have his personal data, his email ID, contact information, address, so everything. Even that one employee is personal data. There is no bifurcation that there has to be, for the applicability of the act, you need 1 million people. No. For the significant data fiduciary concept, yes, there's a certain threshold of the kind of data or the number of individuals. But to be a data fiduciary, there is no such threshold that is determined. So in this situation, you need to understand that the applicability of the act is going to be there to any and every organization which has employees and which is running a business. The grounds of processing data has to be legitimate. Now, what would this mean? It has to have a valid consent. Today, if you're processing data and you're processing it without the consent, explicit consent about what you're going to do with that data, to taking it from the data principle, the consent, then that's an illegitimate data processing. So for legitimate data processing, you need to take consent first. Second, it has to be for the legitimate purpose for which you have collected. Example, you're a bank and you're opening a bank account. So it's very interesting, the account opening forms, if you've ever read of many banks, I have personally seen that. They have information about you. They will ask you your wife's name. They will ask you your children's name. How many children do you have? Do you have this policy, that policy? They have a whole checklist of information which is highly pertinent to you opening a bank account. So the example really over here is that if somebody is coming to open a bank account with you, it should have only that information collected for which the bank account opening process is required. Just that much. You cannot collect everything under the sun. Now this also means you cannot cross-sell things. You cannot really use information that, oh, my insurance allied company is going to do this, so and so other company. So today, a very simple example being the moment if you book a holiday trip, let's say book flights on any particular platform, you will start getting notifications and messages of hotels in that same place. You will get about different taxi services, good food joints. How does this happen? That's called cross-selling of data. So this entire concept of cross-selling cannot exist. To a great extent, this form of digital marketing also cannot exist. So all of these things are going to undergo a sea change, wherein you cannot really start marketing data. Right now, honestly, if you see what is business intelligence, business analytics, data analytics, all these nice terms along with digital marketing are practically only sale of your data to a great extent. And all of these things will, in a way, be regulated and will have to cease operations in such a fashion. As what I mentioned to you, consent. Now, what do we mean by consent? So with respect to data which is already collected in the past, before the act was enacted, you need to now take a valid consent. If the person does not revert to that, you can continue to process that data. If they explicitly revert stating, don't process my data, you have to stop processing it. From now on, whatever data you will collect, you have to take a valid consent and give a valid consent notice. It has to be clear. It cannot be mixed up in your terms and conditions. It has to be well drafted. It has to be in all the Indian languages. So you can't just have it in English or Hindi or any particular language. All the languages specified in the Constitution, the 8th schedule of the Constitution, you need to provide it in different languages so that everybody can understand what they're consenting to. It has to be explicit, where there has to be somebody agreeing to something with a specific tick, specific click. It cannot be pre-ticked. Pardon? I can't hear you. Yes, it has to cover the purpose, the processors.
For example, Aadhaar card as well as this one. Is it necessary, right, that the thing is, it is given for the as a acknowledgement? Do I have to take that as it? Because most of the time we sign self-certified kind of a what you call the Aadhaar card or the PAN card, correct? So do I have to attach covenant on the top of it?
Yes, before somebody takes that from you also, they need to make you sign off on a consent notice, which is going to contain why they're taking this data from you, what data they're taking, who are the data processors with name, detail, addresses, contact information. It will also contain details if you want to complain, then to the data protection board directly, how you will be able to complain that your data has been misused. All this data needs to be provided. If there are multiple data processors, what are they processing? How they are processing, where they are processing, who are they? Everything has to be there. And let's say there are 10 processors. The person who is giving the data should have the option to select whether or not they want all of them to process, some of them to process, whether or not they're open, like whatever processing is necessary for the purpose of data collection. Let's say for the banking purpose, there are 1 or 2 data processors which are mandatory, without which you cannot provide a banking service. Then in that situation, a data fiduciary can refuse. If you say, I don't want to give consent to these 2 data processors, and you cannot perform the function of opening a bank account without them, then the data fiduciary may not be able to provide you a service.
But if it is digitally, M-mobile and all those things are available, with the consent has been given electronically with a traceability, but banks still insist what are physical documents.
See, that is going to change now. That was all happening till now. The act has come now.
No, so even till today it is going.
Yeah. Pardon?
Till today it is going on.
The act has just come about a month back. It's just been a month. It's going to take time. So just very recently, there was an entire, if you're aware of the Digital India Dialogues, wherein it was mentioned within 30 days, there'll be new rules also for specification of which organizations are going to come in the significant data fiduciary category and what additional rules for data protection board are going to be there. There's going to be a period of 1 year given to comply, after which the penalties to the tune of 250 crores can be levied on anybody and everybody. So you have close to 1 year or maybe 6 months, they're yet to specify. That's a bit stipulated. For organizations which have a global presence, from day 1 they have to comply, which means right now also you cannot be non-compliant because it's presumed you would have had GDPR and you have a certain level of data compliance. For Indian organizations which are solely dealing in Indian data in India, small, medium-scale organizations, for them a 6-month to 1 year period is there. And this 6-month to 1 year period is a very small period actually to get your organization and business fully allied into data protection and framework practices. So this is going to take some time. Even banks are going to go through that process.
Hello, am I audible? Ma'am, I have one question. Hello.
Yeah.
I have one question regarding the consent because the apps, they are actually free apps. We don't have to pay anything. Take any app like a fitness app or any photo edit. First of all, they take consent from you. And people are very eager to use maybe any social media app. First, they take consent. Whatever you are saying, they are already taking consent. Otherwise, you cannot use the app.
There you also have to, then you have to refuse to use the app. Now, if they're providing you fitness service, for the basic fitness service, what consent is required, they can take. The rest of it, if you refuse to give them the consent, then they cannot stop you from using the app either. So what is essential for the service, they have to provide to you. And if they refuse to provide you the service, upon the non-essential consent that you're not giving, you can complain to the data protection board. That option is always there.
Actually, the app get exited automatically.
Pardon?
App get exited. They don't allow to use the app.
That is right now. So as the act, as I mentioned to you, has come into force, there are going to be changes in this, wherein if for the essential part what data they require, you have to consent if you want the app. Otherwise, don't use the app. For the non-essential data that they're collecting from you and processing it, if you refuse that, they cannot stop you from downloading the app. In the event they do that, and they stop you from using the app, please complain to the data protection board. Now, the rights and the duties of a data principal. So the Act very clearly lays down certain rights and certain duties of a data principal. The right to access information about personal data. So today, I may not know who and how my data is being processed. All our data is being processed. We just don't have a fair idea of where and what. So I have the right to approach any organization about what data of mine is being processed by them, by whom and where. The next is right to correction and erasure of personal data. So if there's some wrong data about me, I can get it corrected. I can also seek erasure of my data, where I can tell them I don't want my data processed by you anymore, and please erase all my data which is being processed by you. Something which in India we did not have prior. Right of grievance redressal, which means I can raise my concerns either with the data protection officer of the organization or with the data protection board thereafter. The right to nominate. Now, this is a very, very important right, which is after your demise, what happens to your data? So your data is being processed by multiple organizations, and post your demise, who is going to take the decision of whether or not it should remain, it should be erased, or what should happen with your data? So that is something also which the Indian law provides, which is very interesting because a lot of laws in many countries which are formed on data protection don't have the right to nominate. So this is in a way respecting you and your privacy and your data even after your demise. What are the duties? You need to always ensure that your data is updated. You need to ensure that you're giving the proper information. You're not falsifying and putting up information about somebody else in your name, which is what we call identity theft. So you're not stealing somebody else's data, identity, personal data, and providing it as your own. And you're utilizing the right to correction and erasure in the right way under the Act. What are the duties of a data fiduciary? So data fiduciary is the organization or individual. So it can be a professional. Today, any professional offering you services, whether they're doctors, CAs, all of them are collecting your financial information, your personal data, health information. All of them have to be compliant with the DPDP Act. So all organizations, professionals providing services involving any of your personal data, they have to make reasonable efforts to ensure the completeness and the consistency of data. They must build reasonable security safeguards to prevent a data breach, which means good cyber incident response practices, cyber security, data frameworks, all of that has to be built in. So whether your organization is small, medium, large, irrespective, you have to have it. They must inform the Data Protection Board of India in the case there is any data breach that happens. They must erase personal data as soon as the purpose has been met. So let's say you go and close your bank account in a bank. So a consent manager, the Act stipulates the concept of a consent manager who's going to manage consent. And what exactly this will entail fully is something which the rules thereunder are still to clarify, that what exactly this concept is going to mean. I already mentioned about cross-border data transfer, wherein for certain categories of data, the Act already stipulates the processing has to happen within India, which is a limited concept of data sovereignty. Who are the authorities under the Act now? The authorities under the Act, first of all, is the Data Protection Board, the appellate body, which is TRAI, which is the Telecom Regulatory Authority of India, and thereafter, obviously, the complaints can be escalated further to the courts. What are the penalties? Now, in India, there have been multiple cases where there may be, compensation for certain offenses, penalties for certain offenses. The Indian Data Protection Act has the highest level of penalties, more than the GDPR also. So if you will see, in the case of breach by a data fiduciary in having reasonable security safeguards for personal data, penalty will extend up to 250 crores. Now that is per instance. So in India, we have a huge population. Let's say you're collecting data of 100 people, you're already looking at a very huge fine per instance. Breach in observing the obligation to give the board or affected data principal a notice. So if you've not taken a proper consent notice, 200 crore rupees fine. Breach in observance of additional obligations related to children, 200 crores fine. That is, you need to have verifiable consent of children. You need to ensure that the guardian is involved and is consenting. You cannot direct advertisements at children. You cannot go about targeting children for any kind of product. You cannot profile children. Breach in observance of additional obligations of a significant data fiduciary. So where you don't do the data audit, you don't appoint a data protection officer, where you don't have the DPI, the data protection impact assessment, you're looking at 150 crore rupees of penalty. And breach in observance of duties, 10,000. So where a data principal, so let's say we saw the duties, even you have certain duties. If you fail to perform those duties, you will be charged 10,000 rupees. So from an enterprise perspective, yes, the penalties are very high. From the individual perspective, if you fail to perform your duty as an individual, as a data subject, like you have not corrected your data, you have, let's say, provided wrong data, somebody else's data, the penalty is 10,000 rupees. Breach of any other provision of the Act up to 50 crore rupees. Obviously, as I told you, it can be even professional. So if you're processing data in a professional capacity, now you may be performing a CS service, a legal service, you may be doing anything, but you're processing people's sensitive data, personal data. May not even be sensitive, maybe personal itself. That's more than enough to, that's why even if an organization, maybe an SME, a small organization having 10 employees, you're still under the ambit of the Act. Pardon?
Has been given a wide range of exemptions.
There isn't an exemption that you may say. They are allowed to process your data in the situation of there being a national calamity, where there is a threat to the security. So let's say if there is war, then they can't come and take your consent. If there's a natural calamity like COVID and they need to provide you some services, they can't come and take your consent. So in those exigent situations, yes, they have the power to, in your interest, process your data without consent, which I, in my opinion, feel is quite rationalized, because let's say if there's an earthquake, you can't have government officials running to everybody, please give me your consent, then I need to figure out which hospital to send you to.
How does it operate in the Right to Information Act actually?
Pardon?
You have a Right to Information Act also.
That is for individuals seeking it from the government.
Correct. So if this also has any implication with regard to that?
Yes. So there are amendments to the Right to Information Act also. Even Section 43A of the IT Act has been removed, and this is going to replace that with respect to this. All these penalties, they don't get awarded to you as an individual who's filing the case. So what's going to happen is this goes to the Consolidated Fund of India. So be rest assured, you're not going to get rich in this. But yes, for every offense, the nation is going to get rich. The Consolidated Fund of India is going to get rich. And there you can be quite sure that the board will be very proactive in really ensuring compliance. So it's not individuals who will get any form of compensation. For that, you can actually pursue the criminal remedy is still there. So this is only the civil remedy of penalties. The criminal remedy of filing an FIR with respect to unauthorized access, etc., data breach, that is still there. You can still pursue that for prosecution. You can still, under Section 43, for compensation up to 1 crore, file before the adjudicating officer for the breach of the IT Act provisions. But where any data breach of this nature happens, personal data, etc., the 43A of the IT Act has been replaced by this. So here you will have to complain to the Data Protection Board, which will conduct an inquiry. And if they find merit in your case, they will pull up the organization or the professional, take their side of the story, see is there verifiable compliance, and if that fails, then yes, the penalty which you will pay to the Consolidated Fund of India.
Hello?
You can go under the IT Act seeking compensation up to 1 crore, as I mentioned. You can go to the police, get an FIR registered for, you could say, the person facing criminal ramifications in the matter. But under this particular act, the penalty will go to the Consolidated Fund of India.
I have a question. How government will know which organization has defaulted or breached this law?
Pardon?
How government will know which organization has defaulted? Let's say I have worked with 2 companies and I have shared my mobile number with both of them, and it has been shared with any other organization. How government would get to know which
So when a complaint is filed, they're going to conduct an inquiry. They're going to pull up all those organizations, ask them, first of all, do you have this whole compliance? Show us your data audit, show us your data mapping. That data itself will show where the data has come from to a great extent. So you have to have, as an organization, proof The burden of proof is lying on an organization.
Hello.
Yes.
I have one question.
Yes.
We are having lots of data in our mobile, laptop, and we are having our data in Google Drive also. And we are transferring so many data in WhatsApp. So how much of our data is safe, private?
Well, your data is not safe anywhere. So if you imagine even right now that your data is safe, it has never been safe. The whole concept of safety of data is an illusion. And yes, now the safety and the
So
security
0%
around
is
data.
safety? 0% in safety means everything is open?
Today, if you're having a cell phone and you've downloaded applications, there are multiple applications, well-known applications, I will not name them. They actually continuously take screenshots of your screen. So whether it's your banking transactions, that's how they come to know what is your browsing habits. So India is like a guinea pig for data. So they are profiling us all the time, and we are the guinea pigs for all forms of marketing campaigns for everywhere around the world.
So you mean to say our data is no safe, everything is
It is.
okay?
So until and unless at the end point, at your device level, you have installed anti-spyware, you have installed, there are multiple such applications, if you have actually taken them, then in that situation, to some extent, your data is secure.
One more question, last question. Means there is Google, mainly Google Android Play Store is there, and another government body. They can monitor the application who are asking permissions. Why they are not doing such type of work?
See, they are monitoring everything. Today, individuals are going ahead and downloading every and any kind of application. I'll give you one example. You would have heard a lot of people's organizations' accounts getting frozen recently. Crypto trading, gambling, online gaming, betting. So the government definitely has eyes and ears everywhere. So it's not that nobody knows what's going on. It's just that the law was not there till now to take the action. Now it's there. So you can definitely be assured of action also happening. So with this, I come to the end of my talk, and all the very best for your organization's data compliance.